Welcome to Raj Malhotra's IAS Academy. I'm Surbhi Sirdana, and from today we are starting Prelims Sprint 2022, where we'll be discussing 45 most essential topics for this year's prelims. The most essential topics that you need to study, you must study for cracking, for nailing UPSC Prelims 2022. So let's begin. Since we celebrated Equality Day yesterday on April 14 on the birth anniversary of Dr. B.R. Ambedkar, so our topic for today is from important judgments of Supreme Court. There are many important judgments which have changed the way polity of India functions and how polity of India is defined. These cases will not be explicitly asked in your exam. They have not been asked by UPSC as explicit cases that tell what were the judgments of Kesavanadha Bharati case or coelho case, but their implications on Indian polity, especially on fundamental rights and the functioning of the federal structure of India. Statements regarding those which have been given by Supreme Court in these judgments have been asked time and again. Every year at least 4 to 5 questions can be easily solved if you are well versed with these cases. So today we are taking 11 cases of Indian judiciary, mostly by the Supreme Court. So the disclaimer here is that these are not full explanations. The information here in this video is only limited to solving MCQs, and the facts discussed here are up to date. You can directly rely on them and use them for answering in your prelims this year. So starting with the first case, this will establish the understanding for the further cases that come in this video. The first one is Kesavanadha Bharati case, which is also known as the fundamental rights case of 1973. What you have to remember from here is that here Supreme Court declared that yes, the Parliament has the power to amend all parts of Constitution including fundamental rights, but there is a catch here. The Parliament cannot bring an amendment which changes the basic structure of the Constitution. That amendment should not be in a way that is in contrast to the basic structure of the Constitution. The Supreme Court said that there are some ideals which our forefathers thought of before designing this Constitution, and those ideals have to be kept in mind. Federalism, parliamentary system, supremacy of Constitution, judicial review, all of these are parts of basic structure of Constitution. You have to remember that Kesavanadha Bharati case is related with basic structure of Constitution, and secondly, that basic structure as a term is not written in the Constitution and it is not explained anywhere. Supreme Court from time to time gives out its own interpretations, and the scope of basic structure of Constitution is widening with time. In fact, this is the judgment which is the basis for deciding that which amendment is in consonance with the ideals of Constitution or ideals of basic structure. It empowers the judicial review in our country. Through this power, after this case, Supreme Court has struck down a lot of judgments on the basis that they were not in consonance with the basic structure of Constitution. You can download the PDF of this presentation from the link in the description below and read the entire explanation out for yourself later. Moving on. The second one is Justice K.S. Puttaswamy versus Union of India. He was a retired judge. This judgment is one of the most favorite judgments of UPSC. For the past 3-4 years, UPSC has been continuously asking questions in prelims around this judgment, around the implications of this judgment. So we will discuss this one a lot in detail. Here, Supreme Court established the right to privacy as a fundamental right. And in the previous judgments, in the previous 3-4 judgments on the basis of right to privacy, many high courts and Supreme Court itself ruled that right to privacy is not enshrined in the Constitution. But this was a landmark judgment because here for the first time Supreme Court recognized that right to privacy is covered under Article 21. It is implicitly a part of right to life and dignity, and privacy of an individual is essential aspect of dignity. Privacy enables individual to retain the autonomy of the body and the mind. So since it is a fundamental right, for the infringement of privacy, one can directly approach the High Court or Supreme Court under the given writs. So many of the acts that were passed by the Parliament, especially the Aadhaar Act, which was seen as an infringement on privacy of an individual, many sections of the Aadhaar Act were struck down by Supreme Court. So the thing to remember here is that last year the UPSC directly asked that right to privacy is covered under which of the fundamental rights, and you had to select only one of the rights there, one of the articles there, Article 21, Article 14, 15, 19. But according to this judgment, and if this question again is asked by UPSC and you are asked to tick multiple articles there. So there are 3 articles in which right to privacy is covered. First one is Article 21, where it is explicitly covered. It is integral part of right to life and liberty of the Constitution, and it is also covered in right to equality and right to freedom. Article 14 and 19 also imply right to privacy, but majorly it is covered by Article 21. So it protects the individual from the scrutiny of the state. There are many diverse implications of right to privacy. For example, choosing food habits, choosing the partner of your choice, whom to marry, whom to not marry, and standing against the scrutiny of the state. If the state is infringing your privacy, it is subject to judicial review. All those acts are subject to judicial review because right to privacy is a fundamental right now. So as I said, that you can read about this in detail at your homes by downloading the PDF. Also, one major implication of this was when it declared that right to privacy is a part of Article 21 and it is a part of basic structure of Constitution there. Also, one of the major implications of establishing right to privacy as a fundamental right was that Article 377 was struck down because Supreme Court declared that bodily autonomy is an integral part of right to privacy. It has within its ambit sexual orientation of the individual. So this helped Supreme Court establish equal rights or better rights for the LGBTQ community. Article 377, which criminalized romantic love and private consensual sexual acts between adults of same gender, it was brought down, it was struck by the Supreme Court. So this was a landmark judgment and it derives its powers from this judgment, right to privacy, that was established by the Supreme Court. And unnecessary surveillance by the state or any private party is covered in this. You can directly approach the Supreme Court or High Court in case of unnecessary surveillance. Right to privacy is established as a fundamental right now. The next one is the NALSA judgment of 2014. National Legal Services Authority versus Union of India. Here in the landmark judgment, Supreme Court established transgenders as the third gender in the country. In the next Lok Sabha elections, transgenders were recognized. There were 3 columns under the gender column that was there, male, female, and this other column was added. So that was one step to empowering them. Thirdly, Supreme Court also instructed the governments to treat them as minorities and expand reservations in education, jobs, etc. So all you have to remember is that they got a gender identity from here, from this judgment. Moving on. The next one is one of the most important cases. It's called the Aruna Shanbaug case. See, it talks about passive euthanasia. Now, what is euthanasia? Some people who are in a vegetative state, some people who are likely to not survive. So there is a lot of medical treatment, there is a lot of medical funding and caregivers burden that's there, and for a lot of years these people were entirely on bed in a hospital or in their homes. So euthanasia is actually relieving them of that pain by taking all the medical facilities or the treatments that they are being given to be living on that hospital bed. So there is 2 types of euthanasia. The one is active euthanasia and the second one is passive euthanasia. So euthanasia is the practice of intentionally ending a life in order to relieve pain and suffering. This is also known as mercy killing. So passive euthanasia is nothing but you just remove the plug. It's called pulling the plug. It's called withholding of common treatment such as antibiotics necessary for the continuation of life. While in active euthanasia, people are administered a drug so that they die easily. Active euthanasia is not legal. It's legal. It's not legal anywhere in the world apart from 1 or 2 countries. Passive euthanasia was made legal by this Aruna Shanbaug case by examining the various details of various patients that have been seen or come to limelight in the past few decades. So the Supreme Court declared that the right to die with dignity is a fundamental right which is covered under Article 21 of the Constitution. So this was the first time that the Supreme Court established right to die with dignity as a part of right to life. And it passed an order that allowing end of life care in common parlance is allowed in India. Passive euthanasia is now legal in India. The details that you have to think about here is a living will. Living will is an advance directive by the patient to the physician that if that person goes into a vegetative state, so what time, what all measures can be taken. So passive euthanasia can be allowed in those cases. In chronic terminal illnesses where patients have the sensible, when patients are sensible enough to decide for themselves. Moving on. The next one is the coelho case, or it is also known as the 9th schedule case of 2007. It has been asked by UPSC in one of the mains examination also. In prelims, UPSC has been twisting terms and it has asked it in prelims a lot of times by just changing the statement. So make sure that you prepare this one. This is very important. This case removed the shield that the legislature took to protect the laws violative of the fundamental rights from judicial review. What used to happen was this 9th schedule was added. It was added by the First Amendment to the Constitution because there was a lot of land reorganization laws that had to be passed to ensure equality in the country. So every time judicial review could not take place. So what Parliament used to do is, or state governments used to do, that they used to place some laws in the 9th schedule, and 9th schedule was shielded from judicial review. But after Kesavanadha Bharati judgment, we know that yes, Parliament can amend all parts of the Constitution. It can put laws in 9th schedule also. But nothing is immune from judicial review if it violates the basic structure of Constitution. So in coelho case judgment, in this 9th schedule case, Supreme Court established that if a law is included in the 9th schedule of Indian Constitution, it can still be examined and confronted in court if it violates the basic structure of Constitution. So it had this 9th schedule had earlier tied the hands of judiciary, that no, judiciary cannot come in this matter, it cannot touch the 9th schedule. But and earlier, even if a law was violating fundamental rights of people, it could not be touched by judiciary, and judiciary could not, the judicial system could not bring fundamental rights back into action. But after this case, basic structure was given more strength and it was established that yes, 9th schedule is subject to judicial review if it violates the basic structure of the Constitution. So it also declared that there cannot be any blanket immunity from judicial review of laws included here. So no blanket immunity, unlike earlier. The next one is the Shreya single case of 2015. What you have to remember here is that Supreme Court struck down section 66A of the Information Technology Act 2000. So in 2008, section 66A was brought up in the IT Act. Why was it brought up? Because social media was gaining influence. So the Parliament brought up this section in this IT Act to ensure that social media is not used as a platform to incite hate or is not misused to pass any derogatory comments to somebody or cause annoyance. So what happened was that in around 2015, a very big incident took place and some girls from one of the states commented on it and they were arrested. This act, this section 66A allowed the police to arrest people, and it also, like, there was 3 years jail penalty which was there according to this section. Supreme Court struck down section 66A. It said that free speech on internet is a part of right to freedom of speech and expression of the people of India and they need to have it. So what they ensured was that section 66A is unconstitutional. Why? Because it is violative of Article 19(1) Part A of the Constitution, and Article 19, which has like some provisions where the state can restrict free speech and expression. It said that no, it is not valid here because whatever free speech and expression you are restricting, the legislatures are restricting through this act, it is very subjective in nature. It is causing very subjective interpretation. So for example, if somebody passes a comment, it might be perceived as positive by somebody, but it could be perceived as negative by a policeman or a police authority, and it could be used by people in power for their vested interest, because something that is subject to that is meant for subjective interpretation can be used anyway, positively or negatively. So Supreme Court just came out with this idea that we are striking this down as it is unconstitutional. It is against the right to freedom of speech and expression of people. So Article 19(1) it gives people the right to speech and expression, whereas 19(2) accords the state power to impose reasonable restrictions. So Supreme Court said that these are not reasonable restrictions. free speech on the internet is a part of right to freedom of speech and expression, and reasonable restrictions cannot be imposed under Article 66A. After this, there was a lot of hue and cry, and Mr. T.K. Vishwanathan committee was set up to deal with cyber crimes, especially online hate speech in India. So make sure that you know the name of this committee. The next one is Lily Thomas and Union of India case 2013. This judgment was given by Supreme Court to prevent criminalization of politics. What used to happen was that if a sitting MLA or MP is convicted, if it is said that this person has committed this crime and the judiciary is giving these many years of jail term or such and such punishment to this person. So earlier, Section 8 Part 4 of the Representation of Public Act, it said that it gave a blanket immunity. It gave a immunity to sitting MLAs and MPs, that they were not disqualified on the day they were convicted. That if a judgment has been passed today and the person has been declared as a criminal, that yes, this person has done some wrong. So on that particular day, a person should be leaving his seat, as is the case now. But earlier this was not happening. Section 8 Part 4 of RPA had many provisions which gave immunity to people. They could file these appeal for revision of the sentence they have been given, and they could not be disqualified for the next 3 months. And after that, this appeal, since the decision for this appeal used to come for the time, they used to have that immunity for that particular time. But Supreme Court came out with this judgment that any member of Legislative Assembly, member of Legislative Council or member of Parliament who was found guilty of a crime and given a minimum 2-year imprisonment, he or she will lose membership on the date, from the date starting on the very date on which that person has been convicted, or with an immediate effect. So she will have to leave the house. His seat would be gone. The next one is, the 8th one is NOTA, that is the right to negative voting. When we go for elections, either we can put an impression, or we can choose the candidate or party that we want, or there is none of the above option if you're not happy with the candidates that are standing for election. So the Supreme Court recognized that the people have this power, they have this right to choose none of the above candidates who are standing for elections if they do not like anyone. It is not a compulsion to choose anyone. The catch here is that right to vote in our constitution, it is a legal right, it is a constitutional right, it is not a fundamental right. While right to reject a candidate was established as a fundamental right by Supreme Court of India through this judgment. So right to reject a candidate is a fundamental right of speech and expression that is covered under Article 19 of the Constitution. You have the right to express your will freely, whether to choose a candidate or not to choose any candidate. So make sure that you have this difference in mind. A question on right to vote, what kind of right is this, has already been asked by UPSC Prelims in 2017 or 18. So make sure that this is the next catch, this is the next fact. It could be asked anytime. So make sure that you remember it. The next one is the S.R. Bommai case of 1994. Here Supreme Court established it actually prevented the misuse of Article 356. What is Article 356? It is used to impose president's rule in a state, and governor in states is acting as the agent of a central government. So many a times a lot of state governments were brought down with malified intentions. So Supreme Court saw this in S.R. Bommai case of 1994, and it declared that whatever state government has been dismissed, that decision of the president is subject to judicial review, because federalism is a basic structure of is part of basic structure of constitution. So what it said in detail was that the power of president to dismiss a state government is not absolute. It has to be passed by both houses of the parliament in 2 months with a simple majority. Till that time only suspension of the state government can take place, and if the parliament does not pass it does not pass the bill for the motion order for dismissing the state government, then the state government will come back into action after 2 months. So it will be revived, and even if it is not revived, it is subject to judicial review. The court made it amply clear that a presidential proclamation under Article 356, it's not absolute, it is subject to judicial review. So it also categorically ruled that the floor of the assembly is the only forum that should test the majority of the government of the day, and not some subjective interpretation of the power of prevailing party in that state, and not the subjective opinion of the governor. So the governor will not decide. The floor of the house, the floor of the assembly is the testing ground. There the government has to prove its majority. If it is not able to prove its majority, only then it will be dismissed if it is passed by, if the proclamation of president is passed by both houses of the parliament. So SR Bommai case established federalism in strengthened federalism in India, and it prevented the misuse of Article 356. Moving on, next one is the Menaka Gandhi case. It is a very short fact that we are about to discuss here, that right to move freely in the country itself is a part of right to freedom covered under Article 19 of the Constitution, but right to travel abroad is a part of right to life covered under Article 21 of this Constitution. So make sure that you have this difference in mind. Apart from there, this judgment does not have any facts important for prelims MCQs. So let me read this out for you. The right to move freely throughout the territory of India is bestowed under Article 19 of the Indian Constitution. However, the right to travel abroad has been derived from the right to life and personal liberty provided under Article 21. Here we come to the last case, that is the Kihoto Hollohan case. It was brought into limelight for this 10th schedule or the anti-defection law. 52nd amendment of the country, 52nd amendment of Constitution brought 10th schedule in the Constitution. It was about dealing with defection cases in the parliament. The Supreme Court said in this case, it abjugated that Speaker has the full power of deciding whether a person has defected or not, and the Speaker has the power to dismiss a candidate, to take away his seat. Speaker or the leader of the house, whosoever it is there for the state assemblies also, it can be the chairman also. First of all, Speaker is acting in a quasi-judicial capacity when it is deciding on an anti-defection matter. What we know is that Speaker comes from a particular political party, so his interest could be with his own political party also in dismissing a candidate and blaming him or her for defecting his own party. That yes, the decision of the Speaker of dismissing a candidate on the basis of defection is subject to judicial review, but till this process is going on, the Supreme Court cannot intervene with its own decision. Secondly, this 10th schedule and 52nd amendment is constitutionally valid. It is not constitutionally invalid. So this is all you have to remember from the cases here. Download the PDF for this presentation from the link in the description below. What you can do is, there is a lot of discussion and debate also around this anti-defection law, that a separate tribunal should be set up for dealing with anti-defection cases, but that is still in pipeline. If there is any improvement there, if there is anything there, so we will be discussing it in our current affairs classes. You can refer to that for preparation for current affairs for prelims. These are the only cases which are important from prelims point of view. Make sure that whatever facts or judgments have been given by Supreme Court, especially with respect to fundamental rights and the working of the polity of our country, you keep that in mind and you keep them in your active memory when you are taking options in your prelims examination. So all the best. We'll see you with another discussion tomorrow on one of the most essential topics, and see you. Keep working hard.